Hi, it's Michael Redden again, and I'm an attorney in Minnesota, and you are watching Wealth Preservation TV. Today, we're going to cover another topic that's related to asset protection trusts in particular. As we've covered before, and as we'll probably cover in future episodes as well, there are kind of a couple different strategies that you can use. Okay, there's some strategies that are going to be in your particular state, some strategies use your particular state and then other states, and then there's the offshore option that people have heard about a lot. And we're going to talk about one of those offshore strategies today. It's an offshore asset protection trust. And as always, when we're looking at these kinds of structures and anything to protect your assets, remember, you have to do it before there's a rainy day. You have to do it before there's trouble. If someone's threatening to sue you, if they have sued you, if you have a reason to believe that very soon there's going to be a claim, you can't do this. At least it won't protect you as opposed to those creditors, because that would be a fraudulent transfer. And remember again, you can't put so much stuff in here that you're insolvent, that you basically can't take care of yourself without the trust's help. That's a fraudulent transfer as well. And always remember too that you can't have a perfect plan. Every plan is not going to be able to protect every dollar. The more dollars you try to protect, the less tax efficient it is. And the more dollars you try to protect, you try to make that judge just kind of think, this isn't fair. And judges are people. If you've got that thing locked up and the plaintiff's throwing every creative thing out there in the world, if he's not getting paid at all, then the judge is most likely to look and say, hey, is this a close call? Where are the ties going to go? Would he give the tie to the person who sued you? Potentially. So you don't want to get that going that way. And also remember that you cannot really plan for that litigant who's got millions of dollars or billions of dollars himself and doesn't care how much money he spends. If this guy's going to spend 500 grand to chase down 30,000 bucks just because he's got an axe to grind, it's a principled thing for him, then be prepared for that. That guy is not going to be discouraged by this. He still may not get the money, but he's not going to be discouraged. And the main thing we want to produce with these is protection first and foremost. But we'll make you a hard target. We want to discourage people from suing you and even coming after you, unless they've got a really meritorious claim and they're very sympathetic and they've got money. Those are the only ones that we want to even give an opening to even consider coming after you. Okay, with that in mind, we'll talk about asset protection trusts. And as you remember, maybe from our previous videos there, in the United States and especially in Minnesota, we wanted to avoid having a trust we made for ourselves. That's a self-settled trust. Don't have to worry about that at all when we're talking about these offshore trusts. And we also talked about those third-party trusts where you make it for your wife, make it for someone else, make it for the kids. Those are still fair game in this. Okay, they're still fair game. And just like every other foreign strategy we've got, you've got to worry sometimes about why you're doing it. There needs to be an estate planning perspective, there needs to be an asset protections perspective, but not solely. We also need to make sure it's not just some kind of tax thing, because the IRS and everyone, they're really looking at these offshore structures. You have to report everything. There's some foreign bank account reporting and other things that must be done. We're going to talk about you keep that down, how you can delay that, but those things need to be kept in mind. This is compliance stuff that you do not want to mess with. But if you want to do it right, if you want to keep up with compliance, and you're okay with a little bit of the extra cost around tax time when you're filing these disclosures, an offshore protection trust has a really good benefit and can really protect you. It's one of the only ones that can really protect against those federal claims where the federal court's going to ignore the state's rules about asset protection and property and be able to come through there. Because if the asset is offshore and overseas, they can't get to it. No one can. But also remember too, just like when we were talking about if you lived in a state like Minnesota that didn't have the asset protection trust statute, you can't protect assets as well if they're in one of those states. Remember, if I had a rental property in Minnesota and my asset protection trust was in Nevada, Minnesota courts are probably going to try to find a way to at least levy on that property, but the other property inside the trust is probably sacrosanct. The same thing comes when you're looking at those asset protection trusts that are overseas. You may be able to say, ha, it's overseas, it's in Nevis, it's in the Bahamas, you can't get to it. Well, that can be true for money. It can be true for securities and other kinds of investments. It's probably not true for the actual piece of property, being the equipment, the house, the car that's sitting right there in the United States. So they kind of have a little bit of that limitation, but they've still got to, get around and get through some of these things, right? And still, if those are exposed, some of the other stuff's not. A lot of my clients who look at the offshore piece, unless you just happen to be an international person and you're thinking, hey, I might leave the U.S., I might go back to my home country, or maybe you're one of those people who bought a second passport, because there are several countries that let you buy in and get that. Then maybe that makes sense for you, because you can kind of go over there and take most of the things with you and leave, and that trust isn't bound to the U.S. stuff. But if you're not one of those people, then I tell them, hey, look, put money over there. Don't put everything. Maybe not put the majority of stuff. I would say put into the offshore trust only that stuff that you just can't do without. If you don't want to be any less than $5 million net worth or $2 million net worth, if it's that last stuff for any day, you would leave the country, or you would just sit on your hands and make sure that that money went to the next generation, or make sure that you could wait out that creditor and have to just get by in some other way. Then put that money over there offshore, because that's a really good place for it. It's a really good way to protect it. Now, let's talk about this other stuff, okay? Offshore can sometimes get scary for people because it's complicated. There's extra tax reporting and things like that. Well, we don't have to have it that way right off the bat. Initially, if we have a trustee in the United States and a trustee over in Nevis, if the trustee of the United States is over here and the U.S. courts and government can get jurisdiction over them, it's taxed like a domestic trust. So, and even the assets inside of it could still be over here in the U.S. in a brokerage account, a U.S. bank account. They can still be there at that time, right? Then we don't even have any foreign bank account reporting to do, and the outside trustee takes a fee to be a co-trustee and help keep books and things, and kind of just leaves it there. And then when you get sued, if there's a rainy day, then what happens is there's a flight clause inside the trust. The foreign trustee gets to fire the U.S. trustee, liquidate the assets, pull them overseas, and keep them there. Now there's going to be a foreign trust that's got those other kinds of reporting that goes to the IRS. You may need to do some FBAR and other things, but you delayed those extra expenses until they were needed, and you still got the protection of the trust. There are lots of different jurisdictions people think about. The most classic one's the Cayman Islands. I would personally avoid that particular jurisdiction. It's just well known for abuse and has that stigma, and courts and the IRS will look a little bit closely at it. There are certain banks that are on IRS watch lists that you want to watch. They could be in the Bahamas, they could be somewhere else. You want to watch and avoid those. Generally for my clients, there are two different jurisdictions that I recommend. Nevis in the Caribbean and the Cook Islands, which is by New Zealand. Both of these have great laws. They're very well protected. They don't recognize foreign judgments. And if your creditor wants to get in part of it, they have to fly over to Nevis, fly over to the Cook Islands. They have to put a deposit in there just to get the right to sue. And on top of that, they have to find a lawyer locally who will sue for them. And almost all of them, the vast majority, are involved in the trust industry, so they're going to be conflicted out. If you're thinking about one of these kinds of things, then you really need the assistance of a competent attorney to set them up who has connections overseas. And if you'd like to have more information, schedule a consultation with me, and we'll cover your situation.